The second is DA and the President, 2013 1 SA 248 at para 39, and the third is the Law Society and Others in the President, 2019 3 SA 30 Constitutional Court at para 61 to 65. Generally speaking, what it entails is looking at the process as a whole and determining whether the steps in the process are rationally related to the ends sought to be achieved, and if not, whether the absence of a connection between a particular step, which is part of the means, is so unrelated to the end as to taint the whole process with irrationality. We submit that there is no free-floating standard of fairness that applies to decisions or actions that are not administrative action as contemplated by PAJA. We do, however, point out that the new rules make specific provision for procedural fairness in the Section 194B committee. Rules 129 AD 2 and 3 provide the committee must ensure the inquiry is conducted in a reasonable and procedurally fair manner and must afford the officeholder the right to be heard in his or her defence. That then brings me to Advocate Mkhwebane's challenges to the validity of the rules. May I say that I prepared this note with reference to the heads of argument, and one or two of the points raised in the heads on the other side were not persisted with. When I get to a point of that kind, I shall identify it and not address oral argument on the point, as none was done yesterday. So there are 12 challenges then to the validity.
Just bear in mind that although the applicant not raised every reason in oral argument, they made it clear that they're not granting. That's the way I.
Thank you very much. May I say that the way in which we intend dealing with that then is in relation to those matters which were not canvassed orally. We stand by what is written here, but I shan't detain the court with oral argument on those aspects, and I will identify each such matter. There aren't many of them, as and when that we get to them. The first point is the contention that it was incumbent on the Assembly to consult the Chapter 9 office bearers, and specifically Advocate Mkhwebane, before making the rules. Two reasons are given. The first is the allegation that the Assembly acts as the employer of the public protector and the other Chapter 9 office bearers, and the new rules change their conditions of employment. In this regard, she invokes the rule of law, sections 7 sub 2 and 23 of the Constitution, that's the right to fair labour practice, and as support for this proposition, that their conditions of employment cannot be altered without consulting them. The second point raised in this regard is that it's contended Section 57(1)(b) of the Constitution requires the NA to make rules and orders concerning its business with due regard to representative and participatory democracy, accountability, transparency, and public involvement. Now, that particular contention, the 57(1)(b) contention, was not pressed in argument yesterday. We deal with it in the note at paragraphs 44 to 49. It is also something which comes up in the DIA case, and I shall consequently not address oral argument to you on it today. I shall focus on the first one, namely her contentions that the NA is her employer and has changed the conditions of her employment. As the court knows, we deal with that in our main heads at paras 173 to 175. The main difficulty with this contention is the following. The public protector is not employed by anyone, be it the Assembly or anyone else. The incumbent public protector, like other Chapter 9 office bearers, is the holder of an office created by Chapter 9 of the Constitution to strengthen constitutional democracy in our country. Hence, Section 181(2) of the Constitution makes it clear that the public employer is independent and subject only to the Constitution and the law. The position of the public protector in this regard, I might add, is not dissimilar to the position of the members of this court. You two are not employed by anyone. With respect, you hold important offices created by the relevant chapter of the Constitution. Returning to the Public Protector, her relationship with the Assembly is a special one. It's founded in the Constitution, which assigns 3 specific functions to the Assembly in relation to the Public Protector. Firstly, the Public Protector is appointed by the President on the recommendation of the Assembly in terms of Section 193, 4 and 5 of the Constitution. Secondly, the Public Protector is accountable to the Assembly and must report on her activities and performance of her functions to the Assembly at least once a year in terms of Section 181, 5 of the Constitution. And thirdly, the Public Protector must be removed from office by the President upon the adoption by the Assembly of a resolution calling for her removal as envisaged in 194 of the Constitution. None of the elementary requirements for an employment relationship between the Public Protector and the Assembly are present. In particular, unlike an employee, the Public Protector does not work for the Assembly or assist the Assembly in carrying out or conducting its business. And there's no contract between the Assembly and the Public Protector, let alone an employment contract. Finally, on this issue, and even assuming that the Chapter 9 office bearers are employed by someone, the definitions of misconduct, incompetence, and incapacity in the new rules do not alter their conditions of employment. They were adopted to give meaning to the grounds of misconduct, incapacity, and incompetence set out in Section 1941, in line with the CSC's holding in EFF impeachment. That then takes me to page 18 of my note, paragraph 50. Her second challenge to the new rules. That is that they impermissibly change the thresholds for impeachment in Section 194 of the Constitution. We deal with this issue in our main heads in paragraphs 193.3 and 198, and in our supplementary heads at paragraphs 27 to 30. For 3 main reasons, we submit this contention is unsound. First, while the applicant is right that Section 1941A of the Constitution says simply that the Public Protector, Auditor General, or a member of a Chapter 9 Commission may be removed from office only on the grounds of misconduct, incapacity, or incompetence, in EFF impeachment, dealing with the comparable Section 89(1), the Constitutional Court held that the Assembly is obliged to adopt rules which give meaning to the ground of impeachment. In other words, the drafters of the Constitution left the details relating to these grounds to the Assembly to spell out in its rules regulating the impeachment process. Secondly, in our submission, it is permissible for the Assembly, when drafting the grounds on which Chapter 9 office bearers may be removed from office, to qualify the terms misconduct, incompetence, and incapacity. In fact, I would go so far as to say that will invariably happen when the Assembly carries out its duty, its definitional duty. In so doing, we submit the Assembly may permissibly make impeachment more difficult than would otherwise be the case. The Assembly's defining the grounds of impeachment in this way doesn't involve an impermissible amendment to the Constitution. The reason is that in EFF impeachment, the CC didn't merely authorize the Assembly to adopt rules defining the grounds of impeachment, it made it obligatory for the Assembly to do so. And as regards the proposition about making it more difficult, the basic point is this. This is the ultimate accountability mechanism which inheres in the Assembly. It's for the Assembly to decide, firstly, when defining the circumstances in which an office bearer may be removed, and secondly, when taking the ultimate, what I call the political decision in the Assembly itself, even if a finding is made, whether someone should be removed. In other words, to exercise what my learned friend called the I think it was, he referred to a career death sentence or something to that effect. I mean, that's very dramatic. But it is ultimately for the Assembly to decide what will constitute misconduct, etc., both in general as an institutional predetermination, in the specific instance in the 194 committee, and then to decide whether, if such a finding is made, that the person must be removed from office. The third point that we wish to make relates to the details of these definitions. And if I could ask the court just to get the relevant parts of the rules handy for that. And before dealing with the details, I just ask your ladyship, I'm very happy to continue work until 1 o'clock or at any other convenient time for an adjournment.
We make up for the time starting now. So
Thank you. Thank you. So these definitions, I'd like to focus first on the definitions of incompetence and misconduct. We submit they impose higher thresholds for impeachment than the ordinary meaning of those words would otherwise impose. And we submit that the definition of incapacity doesn't change the threshold either way. Misconduct is defined to mean the intentional or gross negligent failure to meet the standard of behaviour or conduct expected of a holder of public office. That, in the Assembly's estimation, is the circumstance on which, or the circumstances in which it will hold, or a Chapter 9 office bearer is liable to be held ultimately accountable by it. That's not an impermissible amendment of the Constitution. It's an exercise of its power and authority to define. It's done so in a way which raises the threshold. The definition of incompetence.
I remember we heard the argument yesterday, exactly the opposite, that the Assembly is not allowed. What you said.
Yes, the answer to that is very simply in paragraph 177. It is this is of the EFF impeachment. It's evident that the draft has left the details relating to these grounds to the Assembly to spell out. And at the end of the determination of these matters falls within the exclusive jurisdiction of the Assembly. It and it alone is entitled to determine them. This means there must be an institutional predetermination of what a serious violation of the Constitution or the law is, etc. So what we have here is an institutional predetermination of what misconduct is. The Assembly says to Chapter 9 office bearers, misconduct is the intentional or gross negligent failure to meet the standard of behaviour or conduct expected by a holder of public office. That's a legitimate exercise of its power and duty to define these terms institutionally in advance of any case being considered by it. The second is incompetence. Now, this is a non-exhaustive definition. It's got the word includes. It includes the following exacting requirements in relation to the holder of a public office, namely a demonstrated and sustained lack of either the knowledge to carry out, and secondly, the ability or skill to perform his or her duties efficiently. Now, the thing about a definition of that kind is that in relation to the matters that it covers, a lack of knowledge, lack of ability, lack of skill, it covers the field. In other words, it says, if you want to say that someone is incompetent because they lack the knowledge, ability, or skill, then you must have a look at these. You must have a look at how it's defined here. And it must be demonstrated and sustained. And it must have the consequence that the person cannot carry out their duties efficiently. So it's exhaustive of virtually every conceivable circumstance in which someone could be plausibly said to be removable for incompetence. Hence our submission is that it too raises the bar or the threshold higher than the ordinary meaning of the words would otherwise indicate. Turning to the definition of incapacity, we heard quite a lot about that yesterday. As the court is undoubtedly aware, the applicant is not charged with incapacity. But be that as it may, she's brought this challenge generally. The focus was particularly on the inclusion of a temporary condition in paragraph A. Now, although paragraph A, which reads a permanent or temporary condition that impairs the holder of a public officer's ability to perform his or her work, includes temporary incapacity, We submit that does not alter the threshold. The reason is the word temporary relates to the cause of the incapacity and not the incapacity itself. Now, put differently, in cases of both temporary and permanent alleged incapacity, the question for decision, in other words, the requirement, remains the same, namely whether the condition results in the impairment of the Chapter 9 office bearer's ability to perform his or her work. We give the following example of a public protector. As the court knows, they are appointed for a non-renewable period of 7 years under Section 183 of the Constitution. Now, it's conceivable that a public protector may develop a condition which, although temporary, impairs their ability to perform their work and is likely to continue doing so for the balance of their term of office, or perhaps for a significant portion of their term, say the next 2 years. If in such circumstances the public protector doesn't request the Assembly's permission to vacate their office on account of continued ill health in terms of Section 23A of the Public Protector Act, it would be rational and consistent with Section 1941A of the Constitution for the Assembly to remove them from office on its own accord. That brings me then to the third challenge to the rules, and that is that they are unreasonable because she cannot be expected to conform to the new requirements imposed by the definitions of the rules at a time before they came into existence. Just a word about unreasonableness. Unreasonableness is a ground for judicial review of administrative action. It is not a ground on which the rules can be reviewed. But we understand the gist of this point. It's because it also underlies the applicant's claim for the first alternative order she is seeking, namely one declaring that the rules do not operate in relation to her actions before the 3rd of December 2019. It's the issue of retrospectivity, which we deal with in our main heads, paragraphs 192 to 194, and in our supplementary heads, paragraphs 5 to 15. The fundamental problem with this reasoning is that it mistakenly presupposes that the new rules themselves are the source of the Assembly's power to remove office bearers in terms of Chapter 9, to remove Chapter 9 office bearers from office on the grounds of misconduct, etc. They are not. The power derives from Section 194 of the Constitution, which came into operation on the 4th of February 1997. The new rules merely particularize the elements of the grounds for removal and elaborate on the mechanism for removal in Section 194. And once it's submitted as we accepted as we submit, it should be that the date on which the Constitution came into effect is the date from which the Assembly became empowered to remove an office bearer of a Chapter 9 institution in terms of Section 194, and not the date on which the new rules were adopted. The retrospectivity point simply does not arise. Moreover, as the full court pointed out in paragraphs 98 to 100 of its judgment on the relief the applicant is seeking in Part A, that's now reported as Public Protector and the Speaker of the National Assembly and others 2024, All South Africa Report 776, Western Cape Court. 4 points. First, with the exception of criminal trials, as to which we refer the court to Section 35(3)(L) of the Constitution, there is no rule against retrospectivity in our law. There's a presumption, but it can be rebutted either expressly or by necessary implication by the provisions or indications to the contrary in the enactment itself. That's Workmen's Compensation Commission and USTA, 1997 4 SA 418 SCA at 424G. Secondly, one of the circumstances in which such an inference can be drawn is when holding that a measure is not retrospective would lead to an absurdity. That's Leck and the Estate Agents Board, 1978 3 SA 160C at 169 F to G. Thirdly, in our submission, it would be absurd, and this is what the full court held, to interpret the new rules as applying only to events after their adoption. If the new rules didn't operate retrospectively, in the sense of regulating the grounds and process for the impeachment of a Chapter 9 office bearer based on their conduct or performance in the period after their appointment, but before the adoption of the new rules on 3 December 2019, the result would be the following. because the adoption by the Assembly of those new rules is a requirement for all impeachment proceedings under Section 194, that's the EFF impeachment case, no misconduct committed by a Chapter 9 office bearer during that period, or no incompetence manifested by a Chapter 9 office bearer during that period, however grave, could sustain their impeachment.
Mr. Breitenbach, yesterday the applicants have been simple measure for the National Assembly to just include retrospectivity in if they want to in it. And the intuition thereof, bearing in mind at the time when they were looking at the rules, it was already a complaint.
I understand that, but of course it falls because the contention yields the absurdity to which I've just referred. There's no need to say something expressly if it would be absurd to interpret the rules in a contrary fashion. We respectfully commend the reasoning of the full court to this court on that issue. But there is a further reason, which I'll get to, which relates specifically to the content of the rules, and these are the last 2 points. The first thing is the court knows that the rules mainly regulate the procedure to be followed in the future, in other words, after 3 December 2019, for impeachment processes in terms of Section 194 of the Constitution. We've seen what that procedure entails. Insofar as the rules deal with matters of substance, in other words, define incompetence, misconduct, or incapacity, as explained earlier, they impose higher thresholds for impeachment than the ordinary meaning of those words would otherwise impose, and that's in the case of incompetence and misconduct, or don't alter the threshold in the case of incapacity. Consequently, if anything, the new rules favour the incumbents of Chapter 9 officers by making it more difficult to remove them on the grounds of incompetence or misconduct. And the important point is that issues of retrospectivity arise only in respect of changes to the law which would impair existing rights or create new obligations, which is not something that the new rules do in any presently relevant sense, because the retrospective operation of the new rules, if anything, inures to the benefit, or at least not to the detriment of Chapter 9 office bearers. And we refer to Ex parte Christodoulides' 1959-3 essay 838T at 841A to B. Ultimately, yes, it is a question of construction. And there are 2 ultimate problems here. 1, the grounds of impeachment have existed since February 1997. So it's not a question of retrospectivity imposed by the new rules. Secondly, it would be absurd to interpret them as not applying to misconduct, etc., committed during an office bearer's term of office, however grave that may be. And I suppose a third factor that the court can take into account is the court knows the facts. What happened was, shortly after the constitution of the 6th Parliament in May 2019, the then Chief Whip of the DA, Mr. Steenhuisen, lodged a motion for the removal of the applicant as public protector. The public protector wrote to the Speaker in early July 2019 about that, making a number of points, one of which was that the process would be incompetent unless and until new rules dealing specifically with impeachment under Section 194 were adopted. The Speaker referred that matter to the Portfolio Committee on Justice, which essentially agreed and advised her to refer the matter to the Rules Committee of the NA, which she duly did. It itself and through a subcommittee then set about preparing these rules so that there would be a set of rules in place to deal with the removal of Chapter 9 office bearers. The context, in other words, the factual context in which this occurred was against the backdrop of Mr. Steenhuisen's motion, which, as the court knows from the papers, was largely similar to the current motion. The latter has added further events, but the events preceding May 2019 are there too. That is to the extent that the facts might further assist, but the two fundamental points I've made remain. That brings me to paragraph 60. This challenge, the fourth challenge, wasn't persisted with in oral argument, and I shan't therefore address it in oral argument. And that is that the rules are specifically targeted against Advocate Mkhwebane as an individual, in spite of being clothed as rules of general application to all Chapter 9 office bearers, the so-called Sobukwe clause argument. If I could ask the court to turn to page 24 at paragraph 65. The fifth challenge then is that the new rules do not differentiate between the requirements for the impeachment of the president in section 89 of the Constitution and the requirements for the impeachment of the holder of a Chapter 9 office in section 194. We deal with this issue in paragraph 208 of our heads of argument. The short answer is that in drafting and adopting these rules, the Assembly acted rationally, and the rules are themselves rationally related to section 194. We refer the court in this regard to the detailed description of the process of the formulation of the rules in paragraphs 80 to 92 of the Speaker's answering affidavit, where the members of the committee, and particularly the subcommittee of the Rules Committee, gave careful consideration to a set of rules that would fit and regulate the impeachment process in section 194 of the Constitution. We've already looked at some length at the definitions of misconduct, etc., in the rules, and also we refer the court to the description of the interaction between the rules in section 194 in our heads in paragraphs 119 to 144. That's the 17-step process. There can be no doubt that there is a close fit. They are fit for purpose. They meet this test of substantial rationality, in other words. The sixth challenge is in paragraph 68, also not persisted with in oral argument, was that the rules are irrational because they fail to make provision for filtering malicious and or dishonest complaints by conflicted and compromised individuals or any other abuse of process maneuvers. That argument wasn't persisted with, perhaps wisely, but if, to the extent my learned friend would like the court to deal with it, the answer is summarized in paragraphs 69 and 70, to which I shan't address argument now. The seventh challenge, paragraph 71. This challenge was emphasized quite considerably yesterday. It's that the new rules deny the applicant the benefit of audi alteram partem because they do not make any provision for her to be notified by the Speaker of a complaint in the form of a motion that has been lodged against her. Now, we deal with this issue in our main heads at paragraphs 161 to 162. Generally, as regards this challenge, for the reasons given earlier, we submit that as the implementation of the rules is not administrative action regulated by Section 33 of the Constitutional PAJA, the applicable standard is procedural rationality and not procedural fairness. The second point that the court will have seen from the Speaker's affidavit is this. She accepts that the participation of Advocate Mkhwebane in the Section 194 process is necessary for it to fulfill its function as the Constitution's ultimate accountability enhancing mechanism for Chapter 9 office bearers. In other words, she accepts that the participation of Advocate Mkhwebane in the process is necessary for it to be procedurally rational. There is, however, no question of the office bearer being excluded from the process, and consequently of the process being procedurally irrational. The reason for that is the new rules provide the office bearer with two opportunities to answer the charges against her. The first one is when the independent panel conducts the preliminary assessment of whether there is a prima facie evidence to show she committed the misconduct with which she has been charged, or is incompetent for the reasons alleged. We refer in this regard to Rules 129X, 1C, 2 and 3, Roman 2 and 3. During the independent panel proceedings, the office bearer will be at liberty to assert and seek to establish that the motion is non-compliant, either because it does not meet the form and content requirements of Rule 129R, or because it is inconsistent with the Constitution, the law, and or the new rules. The second opportunity is during the proceedings of the Section 194 Committee. We refer in this
I understood the complaint to be twofold. Once, before the Speaker decides that the motion is in order, before that process, there is a courtesy not even to say there is this motion they're going to consider. Further understood the complaint there to be the whole country knows. You could be walking down the passage in your office and your subordinate said, do you know this is against you? That's the one complaint, the way I understood it. The second complaint, the in-order decision affects the incumbent directly and can affect the incumbent negatively. If the incumbent at that point can make an in, we might never get past that step.
And I thank you. I understand those 2 points, and I have categorized them as attacks on the Speaker's decision to approve to hold that the motion was in order. And with your leave, I shall deal with them. I deal with them in detail when I get to that aspect of the case. So, thank you. The second opportunity which the incumbent has to answer the charges against her, as the court knows, is during the proceedings of the Section 194 Committee. We refer to Rules 129A sub 2 and 3, which provide that the committee must ensure that the inquiry is conducted in a procedurally fair manner and afford her the right to be heard in her own defence. Finally, in this regard, the applicant seeks to make something of the fact that on the 26th of February 2020, the Speaker decided to provide her with copies of both of Ms. Mazzoni's motions. We'll deal with this later when addressing her claim for personal and punitive costs against the Speaker, this being the first of the factors on which she relies for that. Her eighth challenge to the new rules, and I'm sticking just to challenges to the new rules rather than to their administration or implementation, is they do not provide for her to be given reasons for decisions adverse to her. Now, we deal with this in our main heads at paragraphs 179 to 181. For two main reasons, we submit that Advocate Mkhwebane, like the incumbent of any other Chapter 9 office whose impeachment is sought, has no right to reasons for any of the following decisions. This is no right to reasons contemporaneously at the time. Quite a different matter whether the decision can be justified, of course, and this is the ultimate decision, if there aren't good reasons for it, and that's something to which I shall come at a moment. No right to reasons for a decision of the Speaker in terms of 129S that a motion for the removal of the office bearer is in order. The second is a decision by the independent panel that there is prima facie evidence substantiating the charges, although the rule does require the panel to submit a report to the NA, which must include the reasons for its recommendations. So the rule requires that the NA be given reasons for the recommendations. So it has the right to those reasons, and indeed, as you will know from my answers earlier to Justice Delamo, the whole point of the exercise is that a reasoned recommendation is given. Thirdly, to a resolution by the Assembly in terms of 129Z that a Section 1794 inquiry be proceeded with. Fourthly, to a decision by the 194 Committee in terms of Section 1941B and Rule 129AE that the office bearer has committed the misconduct or is incompetent or incapacity for the reasons alleged in the motions. But here again, Rule 129AF does require the committee to submit a report to the NA, which must include the reasons for its findings. So again, the National Assembly is entitled to reasons so it can make an informed decision, and the decision in question is a resolution by the Assembly that the office bearer be removed from office in terms of 194.1c, 190 Rule 129AF2. The first reason why the office bearer is not entitled to any reasons is that none of them, these decisions or resolutions, is administrative action subject to PAJA, Sections 5 of which confers a right to reasons for administrative action. The second reason is that there's no requirement in the Constitution or in any other law or in the Assembly rules that reasons be given, and I stress, to the office bearer for the decisions or resolutions. Nor does procedural rationality or any other constitutional rule or principle applicable to the impeachment process require the giving of reasons to the office bearer. But, and here I emphasize, where the Assembly itself requires reasons in order to fulfill its functions in a rational manner, reasons for the independent panel's findings and recommendations, and reasons for the Section 194 Committee's findings, the new rules expressly provide that their reports to the Assembly must contain the necessary reasons. And as the proceedings of the plenary NA and impeachment matters will invariably be conducted in an open manner, the office bearer will be entitled to access those reports. And then just coming to the point which is not in the note, but which I alluded to earlier. Finally, in this regard, I should mention that should a Chapter 9 office bearer challenge a decision to remove them on the ground that the decision by the Section 194 Committee is arbitrary, in other words, that it arbitrarily decided that they committed misconduct or were incompetent or incapacitated, the committee's reasons for its decision in its report to the Assembly must be plausible, because if they aren't, the arbitrariness challenge will succeed for the reasons that the court will know from judgments like the restructuring insolvency practitioners case to which I referred otherwise. And that's an important point to bear in mind. And we are dealing here with a process which is aimed at an assessment, a rational assessment of whether or not an incumbent office bearer should be removed. The process provides for the participation of the office bearer in the screening stage, in other words, a right to be heard by the independent panel before it makes its findings and recommendations to the Assembly, and of course, to participate in a Section 194 committee if that arises. The process provides that the independent panel must report to the Assembly and give reasons for its recommendations. The process also requires that the Section 194 committee must report to the Assembly and give reasons for its findings. That's as far as the process is concerned. So those reasons will become public in the course of the process. If the reasons by the latter, the committee, are arbitrary for those findings, well then of course any removal of the office bearer based on arbitrary reasons cannot stand, because our Constitution has it against arbitrariness. It's one of the fundamentals of legality. And in that respect, and to that extent, the office bearer is, of course, entitled to consider and challenge the decision on a ground of arbitrariness. But that comes after the fact. That brings me to Advocate Mkhwebane's ninth challenge to the rules, and it's one which concerns provision being made in Rule 129V for a judge to be appointed to the independent panel in consultation with the Chief Justice. And the contention is that that violates the principle of the separation of powers between the judiciary and the legislature. She also contends that no law authorizes the Speaker to appoint judges to parliamentary structures. It's convenient to deal with the first of those. I apologize. We deal with them in our main heads at paragraphs 210, 211, and in our supplementary heads at paragraphs 31 to 38. It's convenient to deal first with the lack of formal authority. In other words, her contention that no law authorizes the Speaker to appoint judges to parliamentary structures. The answer to that is in line with EFF impeachment. The new rules regulate the process in the Assembly, including the two sifting mechanisms to determine whether the Chapter 9 office bearer has a case to answer. As the court knows, the second of these is the appointment of the independent panel to assess whether there's prima facie evidence supporting the charge or charges. The adoption by the Assembly of rules regulating that process was something which the Assembly was obliged to do, and it follows from that, we submit, that the rules can validly provide the authority to appoint A, the independent panel, as I discussed with Justice Alamo, or B, a judge to the independent panel. Having said that, there may be separation of powers implications for that. And this point is the real gravamen of the complaint here. Now, before dealing with the applicable legal principles, we point out something which may have been a misconception in the debate yesterday. If one has regard to Rule 129V of the rules, it provides that while the Speaker is obliged to give due consideration to all persons nominated by the political parties represented in the Assembly, it does not say she's obliged to appoint the independent panel from among the nominees. She calls for nominations, but she alone decides who the panel shall be. And that is one of the safeguards to avoid the perception that might be created that this is the UDM judge or the PAC judge. I think the submission was yesterday.
No. She is judge. She had two appointed judges.
Justice Bartman, I'm sorry to interrupt you. Would you mind starting again? I missed everything that you said at the beginning.
Oh, okay. Sorry. Is that better?
Much better.
Yeah. That does not take away the danger.
Well, we're coming out of the process to take you to a break.